Assalamualaikum and hi. My name is NURUL BALQIS HIDAYAH binti Muhammad SUHAIMI. People usually call me BALQIS. My metric number is BALQIS21065469. I was born and raised in Kuantan, Pahang, and currently I still live in Kuantan. Previously, I studied in SMK Abdul Rahman Talib Kuantan for my STPM. Originally, I want to study law because I think a law degree can help me find work in any fields. But after I study law, there are a lot of reasons that makes me want to study law more. Studying law does not only help me gain new knowledge, but at the same time, it helps me develop many skills. For Andika part, there are two issues that can be discussed. First, whether the offer made by Andika is valid. The law that can be applied is Section 2A of Contracts Act 1950. Offer is a proposal made by an offeror which, if accepted by the offeree, that is, the promise according to its term, will create a binding contract. Conditional offer is when an offer made by the offeror with certain conditions which the offeree need to fulfill. If the offeree fails to fulfill the conditions, the offer will not be valid. In this case, the offer made by Andika is actually a conditional offer. In order for the offer to be valid, Atika needs to fulfill all the conditions in the offer. Andika made an offer to sell 3 albums collection of Lee Min Ho to Atika at RM1000 by phone. And he asked Atika to inform the acceptance through WhatsApp before or on 20 June 2022. In order for the offer to be valid, Atika needs to inform the acceptance through WhatsApp either by texting or calling Andika, and she needs to inform the acceptance before or on 20 June 2022. On 20 June morning, Atika called Andika to accept the offer, but she did not call Andika to WhatsApp. Therefore, the offer is not valid because Atika did not fulfill all the conditions in the offer. Secondly, the issue is whether the revocation of offer is effective. The law that can be applied is Section 3, Section 4(3)(b), and Section 5 of Contracts Act 1950. In Section 5, it was stated that revocation of offer need to be done any time before the acceptance is complete. Section 3 and Section 4(3)(b) stated that there must be actual communication of the revocation and it must be shown that the offeree was actually aware of the revocation. But there is no requirement that the revocation must be directly communicated to the offeree. It is sufficient that it can be shown he or she is aware of the revocation prior to the acceptance. In this case, Andika tried to reach Atika to inform about the non-availability of the albums, but his internet connection was not good and he forgot to inform Atika after that. This means that Andika did not inform Atika on the non-availability of the albums. However, Atika found out about the non-availability of the albums from her best friend on 19 June when her best friend came to her house to share her happiness. The revocation of offer that is initiated by Andika was not complete, but Atika did know about the non-availability of the albums from her best friend before she accepted the offer on 20 June morning. This means that the revocation of offer is effective because Atika knew about the non-availability of the albums before she accepted the offer. And there is no requirement that the revocations of offer must be directly communicated to Atika. In conclusion, there is no contract between Andika and Atika because number 1, the offer made by Andika is not a valid offer because Atika did not fulfill all the conditions in the offer, and number 2, the revocation of offer is effective even if Andika did not inform her about the revocation. It is sufficient that Atika knew about the non-availability of the albums before she accepted the offer. For Atika part, there is two issues that can be discussed. First, the issue is whether acceptance made by Atika is valid. The law that can be applied is Section 2B and Section 3 of Contracts Act 1950. Section 3 stated that the communication of the acceptance is deemed to be made by any act or omissions of the party accepting by which he intends to communicate the acceptance. In this case, the offer made by Andika is a conditional offer that requires Atika to inform the acceptance of the offer through WhatsApp and before or on 20 June 2022. On 20 June morning, Atika called Andika to inform him about her acceptance. However, Atika did not call Andika through WhatsApp, which means that she did not meet the conditions of the offer. Therefore, the acceptance made by Atika is not a valid acceptance because she did not contact Andika through WhatsApp. Second, the issue is whether Atika's knowledge of the non-availability of the albums give any effect to the acceptance. The law that can be applied is Section 43B and Section 5 of Contracts Act 1950. In Section 5, it was stated that revocation of offer need to be done anytime before the acceptance is complete. Section 3 and Section 43B stated that there must be actual communication of the revocation and it must be shown that the offeree was actually aware of the revocation. But there is no requirement that the revocation must be directly communicated to the offeree. It is sufficient that it can be shown that he or she is aware of the revocation prior to the acceptance. In this case, Atika knew about the non-availability of the albums on 19 June from her best friend who buy the albums, came to share her happiness. In order for the revocation of offer to be effective, Andika does not have to communicate the revocation of offer to Atika, but it is sufficient that Atika knew about the non-availability of the albums. Therefore, Atika's knowledge of the non-availability of the albums make the revocation of offer effective, and the acceptance made by Atika is not valid because the offer has been revoked. In conclusion, there is no contract between Atika and Andika because number 1, the acceptance made by Atika is not a valid acceptance because she did not contact Andika through WhatsApp, and number 2, the knowledge of the non-availability of the albums make the revocation of offer effective, and Atika cannot accept an offer that has been revoked.